The Antitrust Law Section's 73rd Annual Spring Meeting starts on April 2nd, 2025 in Washington, D.C. The spring meeting is the largest gathering of competition, consumer protection, and data privacy professionals from around the world. Take advantage of the early bird registration discount through February 5th, 2025. For details and registration information, search 2025 Antitrust Spring Meeting or contact AT Registrar at americanbar.org.
Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law Section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is What Makes a Compliance Program Effective? The DOJ's updated Corporate Antitrust Compliance Program Guidance. In November 2024, the Department of Justice Antitrust Division issued updated guidance regarding the division's evaluation of corporate compliance programs in criminal antitrust investigations. The guidance outlines what DOJ views as the responsibility of companies to monitor and minimize risks of criminal antitrust violations, and how the Antitrust Division prosecutors should assess corporate antitrust compliance programs as potential mitigating factors. We'll focus today on some new elements of the updated guidance that companies and their antitrust counsel need to consider. But before we talk about that, I'd like to welcome my co-host, Anora Wang. Hi, Anora.
Hi, Alicia.
Would you like to introduce our guests and kick off the conversation?
Yes, my pleasure. Our first guest, Emma Burnham, is Director of Criminal Enforcement at the U.S. Department of Justice Antitrust Division, where she started out as a criminal section trial attorney in 2014. Before joining the Antitrust Division, Emma had a brief career in private practice and served as a law clerk for Judge Robert Gettleman in the U.S. District Court for the Northern District of Illinois. Welcome to our Curious Amalgam, Emma.
I'm excited to be here.
It's our pleasure to have you. Our second guest, T. St. Matthew Daniel, is a partner and deputy co-chair of the Antitrust Practice Group of Paul Weiss. Before joining Paul Weiss, T. spent 7 years in various roles at the Antitrust Division of the Department of Justice, rising to the position of Assistant Chief of the New York office. And before that, she was in private practice. She is a leader in the Antitrust Law Section of the American Bar Association, where she is currently Vice Chair of the Programs Committee and Conference Chair of the 2025 edition of the Section's annual Women's Roundtable. Welcome to our Curious Amalgam, T.
Thanks, Anora. Happy to be here.
Emma, we'd love to get your help put the guidance into context. At a high level, how does DOJ use the guidance in its work?
Taking a step back, what we do at the Criminal Enforcement Program at DOJ Antitrust is mainly investigate and prosecute antitrust crime. But a core part of our mission is also deterrence on the front end. So we are always looking for ways to better equip companies with the tools that they need to be able to prevent antitrust crime from occurring in the first place. Part of our purpose in issuing this guidance is speaking directly to the business community and to the compliance community to make sure that businesses understand how to build an effective compliance program. We appreciate that people see antitrust compliance as a cost center, and we also appreciate that antitrust is just one piece of a broader compliance program. So when it comes to antitrust, we are trying to set up the right incentive structure so that people understand that, especially for antitrust, compliance really is a cost savings center. To directly answer your question, how our prosecutors use this guidance, we use it in two different places. First, it's something that we focus on when we are deciding whether to charge a company and what type of charge is appropriate. We don't just use this guidance at the end of the day when we're making that charging decision. We're using it throughout an investigation. The questions that are in our guidance are questions that our prosecutors are asking witnesses as we run an investigation. We're trying to understand how employees were trained, what they understood the rules were. We're also trying to understand if the program worked. Did it detect the crime? Is the way the company was able to come to us and self-report it through the compliance program? Because if not, then we have concerns that maybe that compliance program wasn't very effective. Second, we use the guidance at the sentencing stage when we are making our recommendations to courts about what type of sentence is appropriate for a company that committed an antitrust crime. On the one hand, if a company had an effective compliance program, or if it made real efforts to improve a compliance program and remediate after a crime occurred, that can benefit a company in terms of a reduced sentence. But on the other hand, if a company chose to, for example, retain culpable personnel, if a company did not make steps to improve its compliance program, if a company doesn't have a compliance program and chose not to implement one even after a violation occurred, those are factors we are going to consider in deciding that a term of probation is appropriate for a company. And that could include things like ongoing reporting requirements and even a corporate compliance monitor.
That makes great sense. And I think we open the conversation by saying this is updated guidance and compared to its first issuance in 2019, there has been major changes to the updated guidance. Our listeners might be particularly keen about learning about those. So would you please walk us through just a little bit on what does the new guidance say about the use of artificial intelligence?
The use of artificial intelligence is something that we get a lot of questions about. So we thought it was appropriate to include this in our guidance. We understand that companies are enthusiastic to begin deploying these technologies in their businesses. And we want companies to understand that it is important that that deployment doesn't outrun compliance. Compliance should be focused on artificial intelligence, including things like algorithmic pricing tools in areas that may present an antitrust risk, like pricing or sales or even human resources. The compliance part of a business needs to understand what those AI tools are doing and how they're doing it, including things like use of non-public data that the company is obtaining from somewhere outside of the company. And if that tool was a third-party tool, how is that tool being marketed and how is the company making the decision to use that tool? We sometimes hear things like, well, it's just software, so we don't really understand how we would monitor it the same way we monitor a human person. I think our response to that is there needs to be a human person that is overseeing your AI tools. You can't just set this and forget it. There has to be some sort of ongoing oversight. Part of our purpose in this guidance is making sure that the compliance professionals in an organization are empowered to ask the right questions and make sure there is appropriate oversight.
I think that is a strong theme that we're seeing, which is like as the technology evolves, as our environment changes, the guidance is trying to adapt to that new reality. And another, aspect of this development, I guess, is addressing the use and preservation of ephemeral messages. So I think there's new guidance addressing such use and preservation and non-company forms of communication. Would you please give us a sense what drove those changes?
So it is very common in our investigations to see situations where employees are trying to use or are using non-company controlled means of communication. We even see examples where employees are expressly writing, let's move a particular conversation off of email or off of the company controlled server onto some other means of communication, usually an ephemeral messaging tool, or let's change the settings around how those communications are retained. I think we have been clear that in the context of our investigations, the company and its counsel needs to be able to get their hands around the use of ephemeral messaging in those settings and work to preserve those messages. And that's in a situation where we have an investigation. I think that is pretty clear. But we also get questions, which I think are reasonable ones, about how a company is supposed to structure its communications policies and retention policies outside of an investigation.
I'm curious, as you're investigating, and if you see messages like, let's move this to another platform, is that particularly a red flag? Or is that something that would trigger you more to look into the facts around those conversations?
That, and I think T would agree with me on this, is something that we would generally see as a red flag. There's usually a reason when you're trying to take something offline or make sure that it is not preserved or discovered.
So what are some other important updates that we're seeing in this guidance?
One of the other things that I think is important is our focus on how companies use non-disclosure agreements and other policies around employees' ability to report potential issues, both internally within the company and to government enforcement authorities. Part of an effective compliance program is ensuring that employees feel free to report violations. Obviously, the Antitrust Division are very supportive of and encourage whistleblowing, both internally so that companies can detect potential problems and address them, but also we want to make sure that companies are making clear to their employees that they can come straight to us. We have seen, and this is consistent with how other government enforcers and regulators are thinking about this, that the use of NDAs, even if that NDA is not expressly stating you may not do this, which I think NDAs generally do not, because that would probably be void for public policy. But even an NDA that is silent as to an employee's ability to report can, in some situations, discourage reporting. So in our view, best practices would be an NDA that does make explicit that you can report and that is not going to be subject to retaliation. We also have a anti-retaliation statute known as CARA that provides protection to whistleblowers who disclose potential antitrust crimes. Best practice for a company is to make sure that employees know their rights under that statute and know that they won't be subject to retaliation.
For listeners, it's important for you to know we'll have a link to the new guidance on the episode webpage for this episode, as well as a link to a recent interview in Antitrust Magazine, published by the section, with Emma Burnham, talking about all the various things that she's been involved in and things that are important to know about what's happening at the Antitrust Division. So now I'd like to turn to T and ask her, from a practitioner's perspective, how is this guidance valuable to you? And what do you think will be some of the biggest challenges your clients are going to face in incorporating the revisions to the guidance into their compliance programs?
I think, Emma's highlighted a lot of the value of the guidance already, just in terms of sort of articulating what the DOJ or the Antitrust Division is focused on, areas of focus and enforcement concerns. So that's a real sort of part of the value of the guidance. I think from a practitioner's perspective, the guidance also adds real value by just putting it all in one place and highlighting some of the important features of an effective compliance program. If you could think of it perhaps as industry best practices that have the DOJ stamp of approval. And I think as a former DOJ prosecutor, one of the things you hear a lot from people is, what does DOJ want? What does the Antitrust Division want? A lot of energy and time put into trying to figure that out. And what this guidance does is it helps you with that. It helps you answer that question and helps you sort of break it down and effectively communicate those expectations to business people. One of the things I will flag about the updated guidance is that the original version in 2019 was focused exclusively on criminal antitrust compliance. And that focus is essentially maintained in the updated guidance. But there's new language in there as well that says, civil antitrust compliance should also be an important part of any corporate compliance program. And I think that's really helpful for private practitioners, for in-house legal and compliance professionals, Because in an era of, too long, didn't read, everyone is so busy, hopefully they can take the guidance, the announcement of the updated guidance, and use that as a way to sort of grab some attention and maybe secure some more resources for their entire compliance effort in the antitrust space, civil and criminal. They can point to the guidance and say, you know what, this is what DOJ expects. I've looked at our program. I've looked at our organization. Here's where we're doing well. And here's where we may need to invest more. And hopefully that helps them move the needle a little bit with the conversation, because the demand on resources and attention is very real. And that's something DOJ recognizes in the guidance, because buried in there is language that says when the Department of Justice is considering the effectiveness of a compliance program, it will consider whether compliance resources were ever requested and denied. And then they'll want to know what the rationale for that denial is. So hopefully this gives folks some ammunition to go in to have some serious conversations about how compliance resources are being allocated to the different risk areas for a company. As to your question about the biggest challenges, I think, the resources and competing demands obviously are a big challenge. But I think for some other clients, they just have limited resources, period. And so for them, it's going to be understanding that DOJ's expectations of what an effective compliance program will look like for one company versus another will vary. And it's okay if your compliance program is not as fancy or is not as comprehensive as another company's, because it has to reflect the resources you have as well as your risk profile. So I think that's something important to communicate to clients so that they're not overwhelmed and think, well, I can't meet some checklist or standards, so perhaps I don't even try. Another reality I think many companies face, and this is sort of the opposite end of the spectrum, are companies with global operations, multinationals in multiple jurisdictions. And this guidance from DOJ's perspective applies to companies that are in the US, but also companies outside the US that are doing business here or that are doing business into the United States. And so having that conversation and trying to make sure that the company is able to put a compliance program in place that accounts for the nuances in different jurisdictions and meets the expectations of different regulators. And then, if they're in a regulated industry, there's another laundry list of non-competition or antitrust expectations to meet as well. So that is definitely a challenge, but the guidance sort of acknowledges that and it helps. Fundamentally, I think it's about sort of sitting down with the guidance, sitting down with the client and trying to understand where there may be areas for improvement in light of DOJ's revised or updated expectations. Ultimately, companies are just trying to sort of avoid antitrust trouble. And so it's all about what is the coherent compliance program that we can put together for this risk profile with these resources, and then really try to embed it into the company's overall compliance structure and infrastructure and into their corporate culture. And so the guidance, I think, is helpful for that. But, it's only going to get you so far because you have to tailor it and customize it to the company. The challenge with the AI is essentially the compliance professionals really have to embed themselves in that process and understand what the risk is of different technology. And, this may not be their most comfortable place, but they really do have a role in helping to mitigate potential risks with AI in the competition space. And then on the ephemeral messaging, I think it's helpful for companies to just understand that DOJ has very sort of clear views on ephemeral messaging. And the department has even raised the possibility of criminal prosecution in certain circumstances, both of the company, but also of counsel, for failure to maintain copies of ephemeral messages. So this is the sort of area where deterrence and getting it right, hopefully at the outset, can really save a lot of stress and anxiety in the event that there is an investigation.
Those are really good insights, which leads me to the question I have perhaps for both of you, although we'll start with Emma. Let's assume that a company does not have unlimited resources or time or personnel. What might you suggest would be maybe the top 3 priorities, the places to start?
First, following up on what he just said, I think she's exactly right, what she said about AI and compliance professionals needing to get comfortable with that space. I would expand that to just thinking about what other parts of the organization really affect compliance and making sure that compliance professionals are empowered to go into that space. Another I have in mind, in addition to AI, is NDAs. I've heard that the part of the company that writes the NDAs and asks employees to sign them isn't necessarily within the compliance function. So compliance professionals might not know what the NDAs say, and they might not know that having heard about a government investigation, someone at the company is going around papering up everyone with NDAs. We want to make sure that compliance professionals know that that is happening and have the ability to go and say, hey guys, maybe that's not in line with the Justice Department's best practices here. Another, I think, would be the human resources function. We have separate guidance on how we view wage fixing and no poach agreements. I think that compliance professionals would be well served to be able to have a conversation with folks in the HR department and make sure they understand what's going on there as well. Second, I would note that our updated compliance guidance has a number of references to tone from the middle, not just from the top, and to management across the organization, not just senior leadership. I think this is really important. In my experience, working in the middle of a vast bureaucracy, there are times when the senior leadership says one thing, but does that really get filtered down to people who are doing the day-to-day work? It doesn't, unless the people in the middle, the direct supervisors, are echoing that message, reinforcing it, and taking the same approach. I have heard at some larger companies, there's a similar type of dynamic. So I think tone from the top is incredibly important, but I think equally important is tone from the middle. So we are going to be asking, what did the line supervisor here have to say about compliance? Were they just giving lip service to it? Were they undermining the senior leadership's message, or were they supporting it? The third thing is following up on something I said earlier about channels for reporting, just making sure there are real places for individuals to report their concerns, that those concerns are being taken seriously and that they are being followed up on. One of the questions that our prosecutors often ask when we're evaluating a compliance program is, how many reports did you get? Usually people have an answer to that. And then what happened with them? For how many was there follow through? Did you find anything problematic? If you did, what did you do about it? Was anyone disciplined, reprimanded? What did that look like? At that point, we often get a lot of blank stares, and we're going to have to follow up on that. So I think that is an incredibly important place to make sure that you're tracking that information and making sure that that system is actually working.
Well, it sounds like a lot, but at least they're very concrete kinds of steps that can be taken. And so, T, do you have anything to add from the outside perspective?
So I'll just pick up on Emma's last point about the types of questions prosecutors typically ask counsel about the compliance program. And I'll note that those questions often filter in their conversations, in the prosecutor's conversations with fact witnesses, because they're not going to wait to just hear counsel's fancy presentation on the compliance program. They're going to be asking people, so if you thought there was a problem, did you know who to go to? Did you go to them? Do you know what the hotline number is? Do you know what the hotline website is? And some people are very good, right? Because the compliance training has stayed fresh, it stayed relevant, and so they actually remember. Whether they comply with it is a different thing, but at least they're aware that they took the training. It's really important that you update the training, you update the materials, so it doesn't feel for people like a click-through exercise. And when someone asks them about it, they're like, I think I did it. I'm pretty sure I did it, but that's the most that they can give you, because that doesn't really corroborate the very persuasive presentation counsel will want to give about the effectiveness of the program and how it had molded culture. And in this one instance, there might have been a lapse, because if your own people don't remember it, it's a challenge.
Well, this conversation's given everybody who's listening a pretty good idea of the importance of getting a copy of the compliance and reading it cover to cover, because things are different. And I think some programs do need to be updated. So there'll be a lot of work for compliance people to do, for outside antitrust counsel to do, and in-house counsel as well. T, what other resources or educational programs are there for people who want to learn about this in more detail?
There are some great resources. The ABA antitrust section has a lot of great programs and webinars that could help folks sort of stay current on compliance developments in the competition space. And of course, you can also check out the Women's Roundtable, where we will have an all-star panel of female practitioners tackling hot topics in corporate compliance.
Since you've already mentioned the Antitrust Roundtable, it's a perfect switch of gears moment here. Why do we have this roundtable in the first place? And what are the benefits of a conference like this, as opposed to some of the bigger events like the Spring Meeting and Fall Forum?
Love that. All right, I will fill this question. So I am super excited, very honored to serve as the conference chair for the Women's Roundtable that's coming up. The Women's Roundtable launched in 2023 as a biannual conference sponsored by the ABA's antitrust section, and it has gotten support from all corners of the antitrust, consumer protection, and data privacy bar. It has been very humbling to see how folks have rallied around this conference. And it's just really an opportunity to both sort of celebrate the women in the field and the achievements that folks have had, but also an opportunity to foster a sense of community, give folks opportunities and spaces to sort of forge connections with other people, organically find a mentor or just a new phone a friend buddy. And it's just a great conference, and it's going to feature like candid conversations with female enforcers, in-house counsel, attorneys in private practice, and the plaintiffs bar in the defense space, the folks that are making headlines in our practice area. We're going to spotlight the full range of our experiences and perspectives across generations of women practitioners. And we're just hoping, what will set it apart from Spring Meeting and Fall Forum, both amazing programs, is just how much the voices of women in the space are going to be elevated.
For those who are listening in early January 2025, the conference will be in New York on January 30th, 2025, and it's a full day with lots and lots of educational programs, but also some fun networking as well. And if you miss it in 2025, it'll come back in 2 years. Is that right, T?
That's the plan.
Transitioning now to the end of our program, we're not going to let our guests go just yet. We need to find out a little bit more about them as people. So one of the questions we like to ask is, tell us something interesting about yourself that's completely outside of your professional life. So if we can start with Emma.
So I used to work with someone who routinely asked this question during hiring interviews for trial attorneys. For years, I thought this was a trick question, and the correct answer was, there is nothing. I just love my job. I love to work. Turns out it was a real question. And after having learned that, I went through a little journey of self-exploration, realizing that I had no hobbies or interests outside of work and my family and my pets and the normal things like that. But I am pleased to tell you that I do have an interest outside of work now. It's something I discovered this fall, and I want to recommend it to everyone. It is a sport called American football, and they play it in college. They play it professionally in the NFL. You can sit on your couch and watch this all day Saturday, all day Sunday. They even do it on Monday, and sometimes there are games on Thursday. It is so fun to watch. The key is you cannot miss a week. You have to watch it all the time because it's like reality TV. There are story arcs here. There's human drama, and it's the most fascinating, complex sport. It's basically chess, but more complicated. I think I might be the only person in the country who hadn't previously been paying attention to this. but it's
no,
great.
Emma, I'm with you. I'm with you.
It's incredible. And there's life lessons, leadership lessons. The best thing I have learned about this, they play it in quarters. And after each quarter, it's just like done. And then you start fresh. And the thing that I have learned from this is like, you just let the past go and you start anew and you don't worry about what came before. You got to focus on what's ahead of you. It's a beautiful life lesson. And there's many, many more to be learned.
I congratulate you for your discovery of American football. T, is there something unusual or unexpected about yourself that you'd like to share?
I don't even know how to follow up on that, but I will try. So as Emma was talking, I thought, and I really thought hard. And so I decided to share something pretty random. So I'm very focused on 90s sitcoms. Like, I love them. And not the ones that you would necessarily expect. I'm like a big Golden Girls fan. I have like Golden Girls, like swag, things that say like squad goals with the ladies on them. One of my all-time favorites is this show called Living Single. And once upon a time, I had so much brain space, I could recite like nearly every line in that show. And I really do mean that. Like, you feed me a couple of lines and I would just go, right? And this was when TV shows had like 5 seasons and like 20 or 24 episodes. So that's a lot of content. If you haven't seen Living Single, you totally should. It's an amazing cast led by the one and only Queen Latifah. But as I thought about Emma's life lesson about letting things go and leadership lessons, I thought, Living Single has life lessons as well. And maybe why it resonated with a younger me was basically just how empowering it was and a really positive portrayal of female friendships. And one of the lines in the theme song is literally your girl's having your back. And that is just a beautiful message, right? But bonus content, Living Single also has really great male characters, and they're the definition of allies. And so I thought, you know what? I'm going to go with Living Single. We'll follow up leadership lessons with the power of a support system and allies. And I mean, come on, you got to see Living Single. It's epic. So
yeah. I remember that show. It was a good one. I agree. Yeah. I agree. Good writing and a great cast. But maybe we can get off the couch for a minute and play a little game we call the Curious Hat.
And now it's time for the Curious Hat.
The rules of the game are extremely simple. I'll ask Anora to pull a random surprise question from our virtual but very curious hat. So take it away, Anora.
So looking at this magical virtual hat that I have, there is number from 1 through 19, and each of you is going to draw a number of your choice, and I'll read the corresponding question. Emma, can we start with you?
13.
13. What was the last movie you saw, and what did you think of it?
The last movie I saw was also a 1990s classic, Now and Then, featuring an all-star cast of Demi Moore and Christina Ricci and others. And I watched it with my 2 daughters. It is a tale of 12-year-old girls finding themselves and staying lifelong friends.
Sounds like a great choice to watch with your daughters. And now, T, do you have your number of choice?
I'm going to go with 7.
7. Tell us about a teacher who had a major influence on you.
I've been fortunate. I've had some really great teachers. But probably the one I will highlight is, it was a law school professor, and she wrote one of my references for my first summer internship. And she wrote words that I cannot forget. It was essentially like, when you first meet T, you may wonder, but, and I'm like, but who starts a reference like that? Wonder. But then it went on to say some of the nicest things about me. And so, yeah, she was great. She just instilled in us like just a real enjoyment and reverence for the law. We would have these small group meetings with her, and she was very old school, and she would want to hear your thoughts no matter how random they were, which was probably why she said, when you first meet T, she had encouraged me to share my thoughts, and then now she had question marks about them. But I think Professor Hopkins was amazing.
Thank you, T, and thank you so much to Emma Burnham from the DOJ. Thank you, Anora, for being a wonderful co-host, as always. And thank you to listeners. Tune in to our Curious Amalgam next week and every week.
Thank you. you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.